we'll come back on the next cycle. What? Can we do it this cycle?
Your Honor, as this was not set for a plea or trial, we did not issue subpoenas,
Okay.
so we don't know if everyone's available.
It was noted as the last, so it wasn't anticipated, but I figure I'd ask the question anyway. Okay, so we'll come back on October 14th for a regular pretrial, and it'll set us up into the next cycle. The trial cycle for that is the October 28th and November 4th, those 2 weeks.
Thank you, Judge.
We're ready,
Okay.
Judge.
Thank you very much. Mr. Durrell. Okay. Is Ms. Gooden in? No?
Good morning, Your Honor. I have Jacob Arnold, 23 CF 2030.
Hold on a second. Hold on, Ms. Gooden. Okay.
The state and I, we're trying to work this out. We've finally gotten a hold of one of the alleged victims. She's still wanting to go forward. The state has an extended a probation offer, and I'd like to give that to my client. Is there another date, or is today the docket day, or?
Today's docket day. We have jury review, which is a couple days from now.
Then I would ask for a continuance so we can facilitate my client being here and facilitate the paperwork. We are not going to go to trial. It will be a plea.
Okay, so we'll come back on jury review for a plea.
And what is that date?
That is,
Your Honor, I can't.
yeah, August 21st.
May I have one more continuance? I have court with Judge Slechter, and I have to take my daughter and her husband
Okay.
to the airport.
You don't have to tell me why. We have personal things, we have issues. Can you do it tomorrow? If we're just doing a plea?
I'm in Walton with Judge Wells
Okay.
for VOP hearings.
We're circuit, we should.
I think
Just
Judge
kidding.
Wells is on
Just
misdemeanor
kidding.
now, Your Honor.
What's that?
I think Judge Wells is doing misdemeanors now.
He is, but he also covers the felony docket.
Okay.
Or there may be another judge sitting in. I have Judge Wells.
Sure, no, I understand.
Um,
Well, you want to try and get it, so,
I wasn't informed till this morning that we weren't gonna resolve it another way. I need to.
well, one thing I will say, and maybe I haven't made this clear, when we have docket days, the defendants should be here. We don't waive docket days. They've got to be here.
Oh, yes, sir, Your Honor.
And if they were here, it could be resolved. Docket days are getting ready for trial. It's not just another miscellaneous day to do it. But anyway, I haven't made that clear, so that's on me.
Your Honor, can we put
We
it
can,
on?
we can come back on a miscellaneous docket. Well, why don't we'll continue it till October 14th, the next pretrial, just to make sure and keep it on. And if for some reason it's not pled out, this will be the last continuance, and we'll go to trial next time. But in the meantime, let's try and get a jury review, a miscellaneous day. September 12th? Does
Yes,
that
sir.
work, Ms. Gooden?
Yes, sir.
Okay. So we'll come back in the morning, the miscellaneous day, 9/12 for a plea.
Yes, Your Honor.
Okay, good.
The last one I have on your docket is Taylor Copeland,
Hmm.
23 CF 1142. We are trying to schedule depositions. We had depositions scheduled. I had to have surgery, which we had them scheduled, and then I had to cancel it because I had surgery.
Are they rescheduled?
They are being rescheduled.
I know that there have been emails back and forth, Your Honor, we were trying to get a date together. So we are working on it.
I know it's getting old.
But it's old, so.
But this one, it will be a trial unless we,
Okay. Do we
miracle.
anticipate, so let's just, can we get these things, we got a 2-month, if we do a full cycle continues, we got 2 months, are we gonna be able to be ready for trial next time?
Yes, Your Honor.
Your Honor, if these depositions occur, yes, we will be ready for trial.
Why wouldn't they occur? That's what I'm asking.
I
Are
just
we
don't-
gonna get, I mean, I know there's something that can always happen. I'm not interested in all the stuff that might happen. I'm interested as we see here today, do we have time? Are we gonna be able to schedule these depositions? If somebody doesn't show up, I understand, we can't control that.
Your Honor, we will schedule the deposition as soon as we can. I don't know what date she's going to be given. I know that the date that she was given did not work for her, so we're gonna have to find another date for her. I just don't know what date that's gonna be yet, Your Honor, but we are trying.
The date given, I'm in 2 different courtrooms.
Okay, I'm gonna continue this till 10/14. I'm announcing last.
Yes, Your Honor.
So let's get it done, get ready for trial.
Yes, Your Honor. And
If
I
it
believe
could,
that's all I have.
the
Thank
clerk
you,
would
Your
reflect.
Honor.
Thank you, Ms. Gooden. Mr. Durrell.
Thank you, Your Honor. Would you like me to do out of custody or inmates?
Either way.
Come on over, Ms. Burgos. Your Honor, first I have Mr. John Paul Burgos Jimenez. Your Honor, we do have a written plea agreement in this matter. I didn't get the offer until late Friday, so I have not had a chance for my client to sign it yet. If I'll need to have just a minute. I did speak with him this morning, though, so we've gone over everything.
Sure.
You're right there. And Your Honor, if I may hold on to this just to announce.
Go ahead.
Thank you. At this point, Your Honor, Mr. Burgos would withdraw his previously entered plea of not guilty, enter a plea of no contest on case 24 CF 0708. The understanding that he will be sentenced on counts 1 and 2 to 3 years total of probation, the first 6 months community control. So 6 months community control followed by 2.5 years probation, standard probation. Standard fines and costs, no contact with the victims, restitution in the amount of $1,073.60 to Marley Bartlett, B-A-R-T-L-E-T-T. A substance abuse evaluation and any recommended treatment. He must start the evaluation within 30 days, and if there is recommended treatment, start that within 60 days. Counts 1 and 2 will be a withhold of adjudication. On counts 3 through 5, it's 1 year probation. That will be an adjudication of guilt. All counts to run concurrently with each other. In case number 24 CF 1106, the state will announce a null cross.
That's correct, Your Honor.
If I may approach, Your Honor.
You may. So on the, just so we can be clear, there's 5 separate counts. And on the first 2 counts, they're 3 years probation each
Yes,
to
Your
run concurrent. with community control. The 1-year probation, do we have the first, I guess the same thing, it would be the first 6 months would be community control, because it's running parallel.
Yes, Your
Or
Honor,
concurrent.
I think that would be fine.
Okay, but they're all, but I'm just doing it for the record, that those are 1-year probation for each of those 3 charges. So you gotta have a sentence for each of the 3 charges.
Yes, Your Honor.
Okay. So, is the state in agreement?
That's the state's agreement, Your Honor.
Okay. So, Mr. Burgos Jimenez, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Correct.
Okay, so you heard your attorney state the terms of your plea agreement, and I see those same terms. You can put your hand up. Same terms are in your written plea agreement that you've signed. Just want to make sure, have you read this closely, and have you gone over it in detail with your attorney?
Correct.
You understand that by entering this plea agreement here today, you're waiving some valuable legal rights, the right to go to a trial, right to force the state to prove their case. You're waiving that so you can get a final adjudication, final resolution of this today. Is that what you want to do?
That's correct.
And are you entering this freely and voluntarily?
Yes, sir.
Okay, very good. Based upon that testimony, the court will accept your plea. As to counts 1 and 2 in 24 CF 708, the court there'll be a withhold of adjudication. Actually, there's going to be a withhold on all 5 counts?
The counts 3 through 5 are adjudicated. So we're adjudicating on the misdemeanors, withholding on felonies.
Okay, very good. So the first 2, the misdemeanors, there will be a withhold of adjudication. The court will sentence you to 3 years probation on each of the 2 counts. The first 6 months of that 3 years is on community control. I like the term house arrest better. Okay, that's a more accurate statement. You need to make sure you understand. A lot of keeping track and making sure things are squared on that community control. If you don't take that seriously, you're going to be violating back here, and they're going to be coming back asking for some type of a sentence. Okay?
Yes.
And as a condition of this, there's no contact with the victim. Do we need to put the victims' names? Is that Mary Bartlett,
Yes.
the
Your
one
Honor.
where the restitution?
Mary Bartlett and Lila Turber, Turberville.
I think we need to put it in there if we're going to hold them to it. I don't-
Yes, Your Honor.
Thank you. Okay, so it's important, there's no contact with the victims, Marley Bartlett or Leela Tuberville. And there's restitution in the amount of $1,073.60 to Marley Bartlett. Importantly, as a condition of the probation, there's also a substance abuse evaluation and treatment. You gotta start that in 30 days or start the actual treatment in 60. As to counts 3 through 5, the court will sentence you to 1129 probation. In other words, just less than a year, but each of those, actually the first 6 months will also be community control. There'll be an adjudication of guilt on those 3 counts, but they'll all run concurrent with each other. And in the case that actually it's not on the docket today, but we'll add it, 24 CF 1106. Those cases are being null pros by the state, correct?
Yes, Your Honor.
Okay. In addition, there's also the standard fines and costs that go along with this. Okay, any questions?
No, Your Honor.
Okay, thank you very much. You have 30 days to appeal this if you want to.
Your Honor, my next incarcerated is Mr. Marquette Lewis.
Okay? Oh,
And Your Honor, we're asking for one final continuance in this matter, with the understanding it will be for your trial next cycle.
State?
That's fine with the state.
Very good. The court will continue this full cycle till 10:16 and 9 a.m. And the clerk's record will show that this will be the last continuance. We'll either go plea it out next time, or we'll get ready and ramp it up and go to trial.
Yes, sir.
Very good.
Thank
Thank
Your
you
Honor.
very much.
Your Honor, for my out of custody, I have Mr. Stephen Abbott. You have a written plea if I may approach, Your Honor?
You may.
This one's a little less complicated.
Thank you. Would you announce the terms, please?
Yes, Your Honor. At this point, Mr. Abbott withdraws previously entered plea of not guilty, plead no contest to the lesser included offense on count 1 of reckless driving, and the understanding that the state would announce a null pros to counts 2 and 3. He would be sentenced on count 1 to 6 months probation, standard fines and costs.
Very good. Do you have a statutory cite for the reckless?
I
Because the clerk needs that in her minutes.
don't offhand, Your Honor. I can pull it up.
Okay, while you're doing that, I'll go ahead and inquire of the defendant. Mr. Abbott, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay. So you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written plea agreement that you've signed. Just want to make sure you entering this freely and voluntarily and with knowledge.
Yes, sir.
Okay, you understand that by entering into this will be a final resolution of this case, and we're waiving the right to go to a trial.
Yes, sir.
Okay, and you believe this is in your best interest to enter into this?
Yes, sir.
And you made sure you had all your legal questions answered by your attorney.
Yes, sir.
Based upon that testimony, the court will accept your plea agreement. This is the state's agreement as well,
This
right?
is the state's.
The court will accept the plea agreement, and as to count 1, there'll be a lesser included offense of reckless driving, and the statutory cite is?
316.192 sub B.
Okay, thank you. And,
Your Honor, we would ask that the probation be served with JCS.
okay. And the standard court costs will be included in this, and counts 2 through 3 will be null pros by the state, which the court will accept. Okay? Make sure and check in with JCS as soon as possible, okay, sir?
Yes, sir.
Okay. Thank you very much.
And finally, Your Honor, I have Mr. Logan Curtis. And Your Honor, we do have a written plea, if I may retain this to go over the terms.
Okay?
At this time, Your Honor, Mr. Curtis would plead no contest in case 24 CF 285. That will be as charged, with the understanding that on count 1, he will be sentenced as a youthful offender. That's 2 years probation, adjudication withheld, standard fines and costs. I believe it's $515 in court costs on that one, Your Honor. I actually was able to find the costs on that one.
Okay.
Count 2 would be 1 year probation concurrent with count 1. In case 24 CF 251, it will be as charged. Again, count 1 will be youthful offender sentencing, 2 years probation, concurrent with 24 CF 285. Count And that comes with a 1-year driver's license suspension as well, Your Honor. 24 hours of community service that he may buy out. Count 2 will be 1-year probation. All the counts are concurrent with each other and with each case, Your Honor. Count 3 will be 6 months probation, again concurrent with all counts and cases.
Okay,
If I may,
thank you. Is that the agreement for the state?
Let's see.
Your Honor, for case 2024 CF 285, I'm only showing one charge. According to the information.
When I pulled it up, I thought when I pulled it up on the clerk's side, it had both.
It's just,
It's what?
So there is no count 2 on that case, Your Honor.
there's one count and it's flinging it to McGill to adjourn.
And then on 251, is that correct? There are 3?
Yes, sir.
And Your Honor, we would ask to merge and dismiss the citations in this case as well. There's 24 TR 2724 and 2737. I believe one is a careless driving and the other is no motorcycle endorsement.
Go ahead and put that in here.
Your Honor,
Kind of
the
scratch
state-
out count 2
The
as well.
state doesn't object to that.
Thank you, Your Honor. Again, I don't believe that has discussed it.
Okay, thank you. That's why we look at them while you're reading them to try and make sure and clarify exactly. Mr. Curtis, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms of your plea agreement, correct?
Yes, sir.
And you've also signed the written plea agreement that contains those same terms.
Yes, sir.
I just want to make sure you read this closely and gone over it in detail with your attorney? Yes?
Yes, sir.
And have you made sure and had all your legal questions answered regarding the plea?
Yes, sir.
You understand importantly you're waiving some valuable constitutional rights
Yes, sir.
in order to get here? Is that what you want to do here today? You believe that's in your best interest?
Yes, sir.
And you're doing this freely and voluntarily?
Yes, sir.
Okay. Did I ask the state if they are in agreement?
I don't recall, Your Honor, but yes, that is the state's agreement.
Okay. Very good. So based upon that testimony, the court will accept your plea agreement. There's actually two counts here, not 2 counts, but there's 4 counts. There's 2 cases. In case number 2024 CF 251, there's 3 counts. In count 1, there'll be youthful offender sentencing, 2 years probation, $515 in court costs, 24 hours community service that you may buy out, 1 year driver's license suspension. Count 2 of 251, 1 year probation, concurrent with count 1. Count 3 is 6 months probation, concurrent with both counts 1 and 2. In 24 CF 285, also youthful offender sentencing, 2 years probation, concurrent with 24 CF 251, merge and dismiss the 2 traffic, 24 TR 2724 and 2737. What's the maximum sentence on the two fleeing and eluding with disregard to safety?
Year or that.
15 years.
Yes, it's a second degree felony.
A second-degree felony. You're getting your chance right now.
Yes, sir.
You better take advantage of it, because if you violate this because of the severity of the charges, you're likely to be looking at DOC.
Yes, sir.
You understand that? You know how many, as a percentage, how many probation cases come back into court? 50%. Okay. You got your chance.
Yes, sir.
You better take it seriously. You better be your probation officer. You need to connect up with them. They need to be your new best friend. Don't make them chase you down, figure out where you're at with all this stuff, okay? You got your chance. Good luck.
Thank you.
Thank you.
Have a blessed day.
That's all I have for today, Your Honor.
Thank you very much.
Thank you very much.
Mr. Cotton,
Good morning, Your Honor.
good morning.
Been around two cases on your docket this morning. First one's going to be Mario Aguirre Lopez. I'm not sure if it's under A or L. I think it's under A, Judge.
It is.
Your Honor, that
I only
case-
have one case.
Freemuth may not be on your docket. I had it set for today because we addressed it off the docket last time. So
Okay, that's fine.
That's
As long as we can still address it, but
we can,
I just
Judge.
want to make sure I'm tracking it and the clerk has it as well. Go ahead.
Yes, sir. On Mr. Lopez's case, Your Honor, I met with my client briefly. There was an offer made by the state. I met with Ms. Sandler this morning. I believe what we would like to do is continue that one more time. I will have this case will either resolve, be ready for trial, or we'll have a motion to dismiss filed, all of which can be done this cycle, and we can be ready for trial by the next cycle.
Very good. So we're announcing last continuance. Have the clerk's record reflected. We'll come back on 10/14 at 9 a.m. next full cycle.
What was that date, 10/14, Judge?
10/14, yes.
Thank you, Your Honor. Who's Michelle?
Yes.
She is, okay.
Yes. Your Honor, admitting that, that's what they spoke about. And I will make sure Ms. Sandler knows it's going to be next.
Okay.
Ms.
So-
Sandler and I have been working on this case for a
Sure.
long time, Judge.
Yeah, I
We're getting there.
I noticed the date.
Your Honor, with regard to Mr. Freemuth,
Why don't you announce that, because I don't have that on my docket.
I will. Your Honor, State of Florida versus Taylor Freemuth, 24 CF 229. Your Honor, that's not on your docket because a plea was originally filed. We were coming back because it didn't specify specifically JCS probation. In the meantime, do you mind if we approach just because I've got to, thank you.
Sure, sure. .229, correct?
That's correct, Your Honor.
We're going to go ahead and continue this full cycle till 10/14 at 9 a.m.
Perfect. And if we can get it resolved before the judge, we'll put it on a miscellaneous and come on.
Very good.
All right.
Okay.
Your Honor,
Thank
that's
you.
all I have before the court.
Appreciate it. Yes,
Thanks,
have a
Judge.
nice day. Mr. LaPella. Good morning.
Motion to approach, Your Honor.
You may. Thank you. would you announce the
Yes.
terms of the agreement?
Sean Lupella for the record, representing J. Christopher Burns on 23 CF 1163. Mr. Burns is present and is entering a plea of no contest. Here, stand right here. Withdrawing his previously entered plea of not guilty. He's pleading only to count 1, and that's a lesser included offense of simple battery, misdemeanor level. And in pursuant to the agreement, the state is going to dismiss counts 2 and 3. As to count 1, which is the lesser included simple battery, he'd be adjudicated guilty and be sentenced to 11 months, 29 days probation, and he'll be reporting to JCS misdemeanor probation. As a special condition of that probation, he'll have to have no contact with the alleged victim, random urinalysis, and not ingest any drugs without a prescription. Also, he'll be subject to misdemeanor court costs and misdemeanor probation fees. And he's also to complete the batter's intervention program as a condition.
Very good. I ask you to do 2 things on this to clarify. One, can you put the lesser included statutory site and also put the name of the victim? Because I don't think we can hold your client accountable to that without having a name in there. Here you go. Take your time. Thank you. Okay, thanks.
Change has been made, Your Honor.
Very good, thank you. And that statutory site for the clerk is 784.031A. So, Mr. Burns, would you raise your right hand, sir? Do you swear or raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth so help you God? Okay, speaking to that mic for me.
Yes, I
Is the
do.
state in agreement on this?
Yes.
Okay. So, Mr. Burns, you heard your attorney state the terms of your plea agreement, and those same terms are in the written plea agreement that I see you've signed. My first question is, did you read this closely and go over it in detail with your attorney?
Yes, I did.
And you understand that by entering into this plea agreement, obviously it's a good plea agreement here for you, but you are waiving some valuable legal rights to get to this point, to get a resolution of this. Do you understand that? Gone
sir.
over it with your attorney? And you believe this is in your best interest?
Yes, sir.
Just want to make sure you're entering this freely and voluntarily. I don't want to,
Yes,
later
sir, I am.
sometimes people say, twisted my arm to do that. Very good. Based upon that, the court will accept your plea agreement. Counts 2 and 3 are being null pros by the state, correct?
Yes, Your Honor.
And in exchange for that, the defendant is pleading and will be sentenced to the lesser included charge of misdemeanor battery, simple battery only. In addition, there'll be basically 1 year or 11 months, 29 days probation misdemeanor with JCS. As a condition of that probation, you must have no contact with the victim, Pamela Kelly, random UAs, no drugs without a prescription, misdemeanor standard court cost, and must complete the batter's intervention program. That's a fairly long program, so you need to get on that. If not, you're going to bump right up against your 1 year probation on it. And also, just by way of explanation, these no contact orders are one way. I just want to say, I don't know what the relationship is with the victim and all that. But if she would call you or come up to you, you're in violation, she's not. So you have an affirmative obligation to stay away from her. If she tries to call you, if she tries to text you, you need to let somebody know that she's doing that and do it. But you have the obligation to stay away from her. That's the reason why I'm raising that, is that those can be real touchy, and they will violate these probations pretty quickly if you
I've already done that, Your Honor, so.
Okie dokie. Any other questions?
Couple questions, Your
Yes,
Honor.
sir.
We defer to the clerk as far as the misdemeanor court cost amount. I'm not sure
She'll
exactly
tell
what that is.
She's very good about that.
Battery, I'm not sure what that is.
Six twenty-two.
622.
622. And then probation fees at $50 a month.
Correct.
The JCS. And does the clerk have a QR code, or do we need to provide that to him?
We usually provide it. We have a card
Yeah.
that you can contact. So,
Okay, I think that's it for me, Judge.
okay, thank you very much. I think you got to get fingerprinted. Go ahead. Here you go. Ms. Merrifield,
Morning, Your Honor.
good morning.
First case I have is Tiara Allen, and these should be listed there.
Yes, I've got it. Thank you.
That's 24 CF 732. We set Miss Allen for docket day without subpoenas in anticipation of a written plea. We do still anticipate that. The state has one other item that they are reviewing. It's going to be a plea in absentia, Judge. We just need to work on the terms and what they're gonna be. If we could set it for the 9/12 miscellaneous, we may get this resolved long before that.
Okay. We'll continue until 9/12 at 9 a.m.
Thank you, Judge. And there is a waiver on file for Ms. Allen. The
Very
next
good.
case I
Thank you.
have is Joseph Benison in 23 CF 2171. I would ask the court just for a little bit more time this morning so that I can continue going over some of the last final concerns. He also has a little bit of an issue ambulating.
Sure,
So-
that's fine. We'll just pass over this. You
Thank you, Judge.
just wave at me if you, when you're ready to go with it.
And the last case, Judge, I have is Kyle Chapman in 23 CF 1015. Mr. Chapman is present and approaching. Judge, if we may approach on Mr. Chapman.
You may.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
So based on the discussion with council, we will have a full cycle continuance. We'll come back on October 14th at 9 a.m.
Thank you, Judge.
Okay.
And I'll reapproach with Mr. Benson in a few.
Very good.
Thank you.
Mr. Garrett.
Down the hall.
Okay. That's all right. Whenever he's ready, that's all right. We'll just pass over. Mr. Shaw. Morning, Mr. Shaw.
Good morning, Judge. First case I have on the docket is Jeffrey Scott Botcher. There's 2 case numbers, 23 CF 2503, 23 CF 2510. Judge, we have a written plea agreement. May I announce the terms?
You may.
Judge, as to, at this time, Mr. Botcher withdraw his previously entered plea of not guilty, tender a plea of no contest as to count 2 on 23 CF 2510. 23 CF 2503, would be no prost. The firearm in that case would be returned to the owner, Mike Davis, upon showing proof of ownership and eligibility to possess a firearm. In 23 CF 2510, count 1 would be no prost. Count 2 would be pled as charged to possession of controlled substance, 24 months probation, may transfer to Alabama, comply with interstate compact. I have already spoken with probation this morning. 615 fines and court costs, 40 a month cost of supervision. He would be adjudicated on count 2 of 23, 2510 only. May I approach that?
You may. State in agreement?
Yes, Your Honor, that's the state's agreement.
Only one small clarification, and that is, like you say, you talked with probation. We don't have anything to do with the transfers. But probation generally, it's not a problem. I just want to make sure that it's not a part of this plea here today.
Yes, sir.
Okay? So, Mr. Botcher, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I swear.
Now, this is a little different than what you just said, Mr. Shaw. You just said the firearm's going to be, did you say, did I miss that you said it was going to be returned to Mike Davis?
Yeah, a gentleman named Mike Davis. It's not
Okay,
his firearm.
that's fine, okay. That's the problem when you don't have it in front of you, can't follow it as well. Okay, so, Mr. Botcher, I see that you've signed a written plea agreement that your attorney just went over, and just want to make sure, one, that you have read this plea agreement, gone over it in detail with your attorney,
Yes, sir.
had all your legal questions answered,
Yes, sir.
and you understand that by entering this, you're waiving some valuable legal rights and constitutional rights to confrontation, all that stuff.
I do.
Okay, and you believe this is in your best interest to enter into this plea agreement?
I do.
Okay. Nobody threatened or coerced you, get you to enter into the plea?
No, sir.
Very good. Based upon that testimony, the court will accept the plea. Did I ask the state if they're in agreement on that?
Your Honor, this is the state's agreement.
Okay. So there are two cases. The possession of a weapon by a felon, 23 CF 2503. The state is null processing that, and they're also null processing count 1, 23 CF 2510. So all we're dealing with is count 2, possession of a controlled substance in 2510. And in that case, the defendant will be sentenced to 24 months probation. And again, it says here may transfer to Alabama. Certainly we're not opposed to it, but you must comply with the interstate compact. They're the ones that decide this.
Yes.
Standard fees and cost of supervision during the course. This is just standard probation as it relates to that. So, and count 1, as I said before, is null process. The firearm in 2503 is going to be returned to Mr. Mike Davis upon the showing of that he owns it, he's eligible to possess a firearm. Okay? Any questions?
No, sir.
Okay. Thank you very much.
Next case I have, Judge, is Patrick Sammy Broadnax. He's making his way to the 23 CF 14. There's a TR case as well, 23 TR 44. Judge, the state and I have actually this morning reached an agreement to enter into a DPA. She's going to draft that up and send it over to me. That will dispose of this. Can we put it on a quicker miscellaneous day instead of a full? I don't.
Sure.
How much time do you think you need to give?
I can do that this afternoon.
If it's an actual DPA, you won't have to come back, but we'll schedule it for whenever you want. You want to do it, just do a full cycle continuous, it'll drop off when you get the DPA ready?
That's fine.
Okay.
That's fine with this right
Okay, so we'll come back on 10/14 at 9 AM, and then if, again, if you do that, it'll fall off at that point.
Thank you, Judge.
Thank you.
Judges, before the court at this time is Robert Leroy Engelkins, that's 23 CF 2169. The state and I discussed an offer last week. I was able to discuss it with Mr. Engelkins on Friday. I need to go through a few more things with him about what certain things mean. I think there'll be a counter offer made to the state as well. We're aware, the court said, that it's going to be tried next cycle if it's not resolved. So, and I've talked to Mr. Engelkins about that.
Okay, so you need a full cycle continuance with the understanding that it'll be the last.
That's correct.
State?
The offer will remain open until pre-trial, Your Honor.
Very good. So we'll continue this matter until 10/14. Give you a chance to, if you can, to resolve it. If not, we'll ramp it up and get ready for trial next cycle.
And I'll ask Mr. Engelkins to be here at pre-trial that day so the
Absolutely.
state can make that
Yeah.
announcement. Thank you, Judge.
Thank you. Mr. Patel?
Good morning today.
Good morning.
Jay Patel on behalf of Joshua Arenas.
Hold on a second, hold on. Sorry, go ahead.
Jay Patel on behalf of Joshua Arenas. We set the case for today in hopes that I would get some pending discovery that we found out during a deposition, particularly an Air Force special agent. I've not gotten that name yet, and we had given a counteroffer to the state. Hadn't heard back on that. As such, I'd ask that this set be to the next October 14th date.
State?
Your Honor, I will get the information. I'm sorry, Mr. Patel, I thought that had been sent over in the discovery exhibit. I will do that, and Your Honor, I am needing to speak with the victim about his counteroffer. I did call, but she needed me to call her back, and I have not received a call back from her. If you continue this one cycle, I have no problem with us announcing this last continuance unless Mr. Patel thinks there's more to do.
But I don't know. I haven't deposed that individual.
I know you're always reluctant whenever I announce last on this. Is there anything that you're seeing that's an impediment?
Judge, I've
to
just...
trying to get these cases. Obviously, if you've got something that to protect your client's interests that hasn't been provided, we can do it. But short of that, something unforeseen, is this the last cycle? I want to get these things ready. You're a year out, not your fault. I'm not saying it's your fault, but we're over a year, so everyone kind of gets.
Judge, I've been doing this long enough to know that it's not in my client's best interest for me to box myself in. I have no idea.
Yeah, but you're the only defense counsel that's not boxing themselves in. We also have to move our case.
I understand.
So court's announcing it's the last cycle. If you have some exigent, court absolutely will hear it.
Would love to be able to do a deposition
Very
and finish
good.
discovery.
I hope that, darn sure, if they don't provide that to you, you'll be getting a continuance. Promise you. How about that?
Sounds good, Judge.
Thank you. Okay, Mr. Garrett, you've been here, I'm sorry.
Oh, Your Honor, I can wait result of Mr. Carson's case. I already know Mr. Becky. Good morning, Your Honor. I'm just here on behalf of Jaron Carson, 22 CF 1778, 24 CF 220, and there's a citation, 24 TR 1514.
Your Honor, the state had to amend this score sheet. This will, I can tell the court I will provide it later, but this will not be a downward departure.
Okay.
And Your Honor, we reserve our right to object to any errors in the score sheet.
Absolutely.
If I may approach with the plea and sentencing agreement.
Okay. Would you please announce the terms of the agreement, Mr. Gear?
Yes, Your Honor. In 24, we're entering a change of plea to no contest in 24 CF 220 and admitting the violation in 22 CF 1778. In 24 CF 220, count 1 is amended to the lesser included offense of possession of marijuana more than 20 grams. Counts 2 and 3 remain as charged. The sentence is credit for time served. I believe it was $963 in court costs. We're asking that he be given 90 days to pay the court costs before the court costs are sent to collections. In 22 CF 1778, we'd admit the violation of probation, credit for time served, $100 VOP fee, revoke and terminate supervision, waive non-monetary requirements, and then we'd ask that he be given 90 days from his release from incarceration to pay the court costs before they are sent to collections. The citation in 24 TR 1514, we'd ask that be merged and dismissed. In addition, Your Honor, in 24 CF 220, we would ask that Your Honor waive the driver's license suspension that would ordinarily come with count 2, the possession of a controlled substance. And it will be an adjudication of guilt.
I don't see that on the agreement.
As far as the driver's license suspension, the state doesn't have an objection. I can certainly add that language.
Yeah, Your Honor, the state doesn't have an objection.
Okay, if you all agree to it,
May I approach?
you may. You surprised me a little, Mr. Garrett. We don't normally get that.
If I may approach.
You may. Thank you. Mr. Carson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Did the state say they were in agreement?
Yes, Your Honor, this is the state's agreement.
Okay. So, Mr. Carson, you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. My first question is, have you read this closely
Yes, sir.
and gone over it in detail with your attorney, just to make sure you got all your legal questions answered?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving some valuable constitutional rights, the right to go to a trial, force the state to prove their case, in order to get a final resolution here today. Do you understand that?
Yes, sir.
And you believe that's in your best interest to do that?
Yes, sir.
Okay. You are entering this freely and voluntarily, nobody twisting your arm to get you to enter into this?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement as to count, and all these are no contest pleas. In 24 CF 220 and count 1 is amended to the lesser included offense of possession of marijuana more than 20 grams. The statutory cite is 893.13, 6 in paren, A in paren. And counts 2 and 3 remain as charged. The actual sentence is credit for time served on all 3 of these counts. You've got $615 in court costs, and you will have 90 days after you get out of jail to pay the cost before the court costs get sent to collections. And the driver's license suspension in count 2 is waived. As to count 22 CF 1778, there's an admission of the violation of probation. Again, the sentence is credit for time served. You've got to have, in addition, of course, more fees. $100 VOP fee. You will revoke and terminate supervision. So you're finished with probation. Waive all non-monetary requirements. And again, you'll have 90 days from release in order to pay the court costs before they're sent to collections. And the traffic 24 TR 1514, the citation is merged and dismissed?
What's the adjudication?
That's a good question. What's the adjudication on this? Thank you.
Your Honor, it's adjudicated on 24 CF 220 is an adjudication for all counts. 22 CF 1778 is also an adjudication.
Yes, Your Honor, it's a correct for time served.
Okay.
So-
You need to put that on here. Yes, sir. So those would be an adjudication of guilt on those as changed, those charges that as changed. Do you understand that?
Yes, sir.
Okay. Thank you, Madam Clerk.
Set that right there. Maverick?
Thank you. So any questions, Mr. Carson?
No, sir.
Okay, you do have 30 days to appeal this.
Your Honor, if we could just briefly pass Mr. Feckley, I need to have one quick word with him, and then we'll get his case.
Very good.
Thank you.
Thank you. Mr. Madden, who got here first? Mr. Sanders or Mr. Madden?
Mr. Madden on that.
Oh. About that. Are you,
Good morning, Your Honor.
good morning.
John Madden here on behalf of Douglas Ehrlich, who is approaching. Your Honor, the state and Mr. Ehrlich agreed to Mr. Ehrlich entering into a pretrial intervention agreement.
Okay.
He's going to be entering a plea into that program. If I may approach.
You may. Thank you. So the state, an agreement on this?
Yes, Your Honor, the state is in agreement with that. We've also discussed it with the victim, Your Honor, and she is in agreement as well.
So we have, so both count 1 and count 2 are lesser included offenses, correct?
Yes, Your Honor.
That's correct, Your Honor.
Okay. Mr. Ehrlich, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, Mr. Ehrlich, you've been entered into a plea agreement that where you're pleading no contest to the lesser included charges of an affray. That's Florida Statute 870.01. But you're entering into a pretrial intervention agreement. If successfully completed, your plea will be withdrawn and the charges will be dismissed. If not, if you don't successfully complete that, you go directly to sentencing on these charges. Do you understand? This is kind of a hybrid between a pretrial intervention and a standard plea agreement. Do you understand that?
Yes, Your Honor.
Have you had all of your legal questions answered about this plea agreement with your attorney?
Yes, Your Honor.
And I see you've signed the plea agreement, so I'm not assuming you've read this closely as well.
Yes, sir.
Do you have any further questions regarding this plea agreement? Okay. You understand you're waiving the right to go to a trial by entering this, that whole part of the procedure, not the sentencing, that's still out there, but the actual trial, you're waiving that in order to get to this resolution.
Yes, sir.
Okay, very good. Based upon all that, the court will accept the plea, and the court will accept the no contest plea to the lesser included charges of affray, and sentencing is deferred. You're entering into a pretrial intervention agreement. Successfully completed, the case will be dismissed. If not successfully completed, we go directly to sentencing. The terms of the PTI are listed in the PTI agreement. Any questions?
No, sir.
Thank you.
Thank you.
Thank you, Mr. Mann.
That's all I have, Your Honor, if I may be
You
excused.
may, thank you. Mr. Sanders.
Good morning. Rusty Sanders on behalf of Asher Hallmark in 23 CF 196. And I was a little too ambitious last Wednesday setting this for Monday. One of the offices at the pretrial, the correction services was closed on Friday. I need to get a receipt from them on something. So if I could get the next court date that the court would be inclined to place it on, I'm expecting it to roll off of the docket at that time.
So we want to reset it for a plea?
I think the case is gonna be resolved with the dismissal once I show proof of the completion of the terms.
Okay.
And so there's just the.
Sure. I got it.
Closest docket.
Sure. September 12th?
Thank you very much.
Continue to-
Apologize for the inconvenience. That's all I have, may I be excused?
You may. Thank you.
Thank you.
I'm ready, Judge.
Miss Flaherty. Sorry. Miss Merrifield.
Thank you, Judge, I appreciate it. Yes. We're just making some final revisions. Brandy Merrifield on behalf of Joseph Benison. And Judge, this is 23 CF 2171. Thank the court for giving me a little bit of extra time. And I will approach with that plea in just a moment. If I may approach, Judge?
You may. Thank you. The defense, are you okay with the score sheet?
Yes, Your Honor. And in 23 CF 2171, Mr. Benison is withdrawing his previously entered not guilty plea. He's entering a no contest plea as charged. What will be important to note is he's going to begin the DOC sentence on 9/17/24. One of the hangups that we've had, Judge, is that he had a much needed surgery that has been scheduled, and that is the reason for the deferred sentencing date, but he'll be entering the plea today.
Okay.
Count one would be $615 in court cost and 20.475 months Department of Corrections with credit for all time served. Count two is the 20.475 months Department of Corrections with credit for all time served, and that's going to run concurrently with count one. Similarly, count three, 20.475 months Department of Corrections with credit for all time served, concurrent with count one and two. And then finally, count four is 11 months and 29 days county jail with credit for all time served to run concurrently with all of the counts together. He will begin the DOC sentence on 9/17/24.
How does that work when you have a jail sentence with a DOC sentence? They'll serve with the DOC sentence?
It runs concurrently with, so he would.
I didn't know which one was concurrent.
The jail will run into the DOC, so presumably he would be processed to DOC, and it runs along with that same 20 month.
Nice, thank you.
If he were to fail to appear or receive a new law violation during that time, then it would be a plea to the bench. The state withdraws the intent to seek habitual felony offender sentencing, and all cases and counts are to run concurrently with each other for a total of 20.475 months Department of Corrections. We'd ask that he have 120 days to pay court cost upon his release, and if not, then it would revert to collections, and this would be for an adjudication judge.
So one just point of clarification. The way you worded it says defendant will begin DOC sentencing. Do we sentence on that date, or we sentence today with the sentence beginning on
So
9/17?
he would enter the plea today on his we would set it for the miscellaneous the court has on the 17th, and the sentence, the DOC portion would be imposed during that time. So it's just deferring the entry into DOC to allow him to have this surgery, but he is locked into that plea.
Okay.
With provisions that if he were to fail to appear or receive a new law charge, then it would be.
That's why I think we're not actually sentencing today. We're sentencing on 9/17. We're taking the plea today. But
That would
the
be correct.
actual sentencing will take place. It's not that he'll begin the DOC sentence, we're actually will sentence, because that allows you to have this if he fails to appear.
Yes, Your Honor.
Well, if I sentence him today,
Understand,
I
Judge.
believe he'd be locked into that sentence. And I don't think the state meaning for that. So I'm gonna ask you just to, just say the sentence will occur.
Thank you, Judge Baker.
Sure. Thank you. Yes, that'd be great. Thank you. Thank you very much. Thank you. And the state is in agreement with this?
Yes, Your Honor, that's the statement.
Mr. Bennison, would you please raise your right hand? I just have to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Mr. Bennison, you heard your attorney state in detail the terms of the plea agreement. Those terms are in this written plea agreement as well that you've signed. So my first question is, have you read the plea agreement closely?
Yes,
And have you gone over it in detail with your attorney? Make sure you had all your legal questions answered.
Yes, sir.
And you understand that by entering this, you're waiving the right to go to a trial, you're waiving some other constitutional rights in order to get a final resolution of this today. Is that what you want to do? You believe that's in your best interest?
Yes.
And you have entered this freely and voluntarily?
Yes.
And have you had all your legal questions answered by your attorney about this plea? It's a little bit of a unique plea.
Yes, I have.
Okay. Do you have any questions as we sit here today?
No, sir.
Okay. Very good. Based upon that, then the court will accept the plea agreement, and there will actually be a sentencing on 9/17. Based upon the terms that are contained in here, the 20.475 months on counts 1, 2, and 3, and then count 4 of the 1129. That actual sentencing will take place on 9/17, and those amounts will be maintained so long as you do not fail to appear and there are no new law charges. If you have any of those, then the sentencing could increase from that, okay?
Yes, sir.
Okay. And the state does withdraw the intent to seek habitual felony offender sentencing filed in this action, again, so long as you meet the requirement between now and sentencing.
That's correct.
And all cases and counts will run concurrently with each other, so that the max will be 20.475 months of DOC less any credit for time served. Okay?
Judge, what time would you like to see us back on 9/17?
Morning, 9 o'clock.
Thank you, Your Honor. That
Thank
is
you.
all I have this morning.
Mr. Garrett, is Mr. Feckety ready?
Yes, Your Honor.
You want to do that? Okay. Ms. Merrifield, if you see Mr. Nopes out there, tell him he's up if he's ready to go after.
Your Honor, he indicated that he did have a conference call at 10, but would be back right after that.
That's fine. I just think if he was out there running around and just hanging out. We've got plenty of cases. Mr. Harper. What's that?
Said he's coming, I promise.
That's all right.
Your Honor, Chris Garrett on behalf of Peter Feckety, who is approaching 22 CF 2747. Your Honor, we're going to enter a change of plea here and enter a plea of no contest. Just sign the date right there.
Can you just slide? Could you get one of those chairs? Slide.
Would Your Honor like me to pronounce the sentence, or should I just approach with the plea and sentencing agreement?
Both.
Okay, yes, Your Honor.
Approach if you can, but if you can then announce it, I'd appreciate it. You have 2 copies?
Yes, I do, Your Honor. May I
Okay,
approach?
that'd be great. Just helps me follow along with it a little bit. Okay, would you announce the terms of the agreement?
Yes, Your Honor. It's going to be an adjudication of guilt, 4 years of probation, $967 in court costs, an anger management class, 100 hours of community service work, no contact with the victim, reserve on restitution for 180 days, and Mr. Feckety may pay off the community service work at the statutory rate.
That is the state's agreement, Your Honor, and the state will submit a score sheet, but this is a downward departure based on a legitimate and uncoerced plea agreement.
Okay. Would you identify the victim?
His name is Jordan Turpin, Your Honor.
Would you put that in that?
Yes, Your Honor. May I approach?
Thank you. Can't hold them accountable without having an actual name.
Yes. It's actually Jason Turpin, isn't it?
What's the name? Okay.
That is correct. My apologies, Your Honor. It's Jason Turpin.
Thank you.
If I may approach again?
Thank you. Okay, Mr. Feckety, would you please raise your right hand? Just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so, so you heard your attorney state the terms of the plea agreement. I see those same terms are contained in the written plea agreement that you've signed. So for my first question is, have you read this plea agreement closely? And have you gone over it in detail with your attorney? Make sure you had all your legal questions answered about it.
Yes, sir.
You understand, importantly, it's contained in here that by entering into this plea agreement, in order to get a final resolution, which this is, a final resolution in your case, you're waiving some valuable constitutional rights. Do you understand that?
Yes, sir.
You believe that's in your best interest to waive those rights in order to get this resolution?
At this point, I think that's best feasible option.
Okay. And you are entering this freely and voluntarily, this plea agreement?
Yes, sir.
Okay. And you have had all your legal questions answered by your attorney?
Yes, sir.
Very good. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on the no contest charge, and the court will sentence the defendant to 4 years of probation, $967 in court costs. An anger management course will be a condition of the probation, 100 hours of community service. You must have no contact with the victim, Jason Turpin. The court will reserve on restitution for 180 days so they can bring that back. Your attorney explained that, how that works with restitution. And you may pay off your community service hours at the statutory rate. One thing I would just point out to you, again, don't know all the circumstances surrounding this and your relationship with the victim, but these no contact orders are one-sided. In other words, you're obligated to stay away from him, not vice versa. So theoretically, if he walked up to you in the Walmart store, you'd be in violation. He would. He called you on the phone, you'd be in violation. He wouldn't.
Right.
The only reason I say it, we don't have problems with it, but I just want to make sure that you understand your obligation to receive.
Right.
Once you do that, no, you're not going to get. There's not going to be. You're not going to be tricked into violating it. But it is important to understand. Well, he walked up to me. Doesn't matter. Okay.
Yes, sir.
We want you to be successful on these things, not being
Yes, sir, me too. Thank you.
tripped up on it. Okay.
Yes, sir.
You do have 30 days, even though you just entered into this. You have 30 days to appeal.
Great. Thank you, sir.
Thank you. Good luck.
Thank you, Your Honor. Have a good day.
Garrett, thank you. You have a good day. Mr. Nopes, do you want to do, we can pass over you and.
Just pass it.
Okay, that's fine. We lost Mr. Harper. Where did he go? He's been here all morning.
We got Ms. Parker.
I agree, she's up.
I'm ready.
Ready to go. We're on here.
Okay, I have a couple out of custody clients who are present. Spence, do you want, sorry, do you want me to wait for Spence?
No.
Okay. Okay, I have Spencer Efet, 2023 CF 2145.
Hold on a second, let me, got me all discombobulated by jumping ahead like that.
Eat that.
Okay, we'll do William Egbers, 2024 CF 871.
Egbers, very good.
The state and the defense have reached an agreement in this case that everyone has signed, if I may approach.
You may. Thank you. Will you please announce the agreement?
Yes, Your Honor. In 2024 CF 871, there will be an adjudication of guilt on all counts. Count 1 and Count 2 will be concurrent terms of 36 months of standard probation, substance abuse evaluation within 30 days, and any recommended treatment within 60, 100 hours community service total, not consecutive, $967 in court costs, $150 public defender fee. Unless the state objects, could Mr. Egbers buy out the community service time?
This state doesn't object.
Okay, so he can buy out the community service time at the statutory rate?
You want to put that in here?
Yes.
Thank you. Thank you.
That's count 1 and 2. Count 3 is a misdemeanor. There's credit for time served in that one. Like I said, adjudication of guilt on counts 1 and 2.
State?
That's the state's agreement here.
Very good. Mr. Egbers, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the terms, you can put your hand down. You heard the terms of the plea agreement. And I see those same terms are contained in the written plea agreement. Just want to make sure, first of all, have you read the plea agreement closely and gone over it in detail with your attorney?
Yes, sir.
And you understand that by entering into this plea agreement here today, you're waiving some valuable constitutional rights, the right to force the state to prove their case beyond a reasonable doubt, the ability to confront witnesses, a lot of those things you're waiving in order to get a final resolution here today.
Yes,
Is that
sir.
what you want to do?
Yes, sir.
You believe that's in your best interest?
Yes, sir.
And you are entering this freely and voluntarily?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. There'll be an adjudication of guilt on all 3 counts. As to counts 1,
I'm sorry, Your Honor. I'm so sorry to interrupt. Continue.
okay, did I get it right?
Yes.
Okay. As to counts 1 and 2, there'll be identical sentencing of 36 months probation, standard probation. There is a substance abuse evaluation required within 30 days and followed with any treatment that's recommended, standard fees and services. Is the 100 hours, I think you actually said this, counsel, is the 100 hours total?
It is total.
Okay, we gotta change it. This says either cross one of them out or put 50 for each one, so it's a total of 100 hours.
Yes, I will cross it out in the second count.
Okay.
Probation, so he's just doing the 100. That's not 200. That'd be a lot.
Okay, thank you very much. So, and then lastly, on count 3, that's a misdemeanor. You'll get the technical sentence is credit for time served. And again, you can buy out your community service hours at the standard rate. Okay, any questions?
No, sir.
Good luck, sir.
Thanks, sir.
Ms. Farkas?
Next we'll do Gabrielle Flanagan. There are 2 cases, 2023 CF 1513 and 2023 CF 2122.
Your Honor, the state is announcing a null pros based on the wishes of the victim in both of these cases. Mr. Flanagan is actually present in the courtroom today, and he had a discussion with the state earlier.
Very good. Court will accept the null pros on 1513 and 2122.
Thank you.
I have Mr. EFAT next, 2023 CF 2145.
He is present and approaching.
The state and the defense have reached an agreement in this case. Everybody has signed it. If I may approach.
You may. Thank you. Would you announce the terms?
Yes, Your Honor. In 2023 CF, oh, I realize I have the incorrect case number in there. I have it.
All right. Devil's in the details.
Yes, Your Honor.
Thank you.
Okay, 2023 CF 2145. Mr. EFAT will accept a withhold of adjudication to the lesser included offense of possession of paraphernalia. The statute is there, 893.147 subsection 1. 11 months, 29 days of JCS misdemeanor probation, substance abuse evaluation within 30 days and treatment within 60 days, 24 hours community service, $270 in court costs and $150 fee. And Your Honor, that is the state's agreement.
Mr. EFAT, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see you've signed the plea agreement yourself. Have you reviewed this? Have you read this closely and gone over it in detail with your attorney?
Yes, sir.
You understand that by entering into this plea agreement, you're waiving the right to go to a trial. This will be a final adjudication of your case.
Yes, sir.
You believe that's in your best interest?
I do.
Okay. And you are entering this freely and voluntarily?
Yes, sir.
Based upon that testimony, the court will accept your plea agreement. And there'll be a withhold of adjudication to the lesser included offense of possession of paraphernalia with the statute cited by your attorney. And the court will sentence you to 11 months, 29 days, JCS misdemeanor probation. As a condition of that probation, there will be a substance abuse evaluation you must do within 30 days, start any treatment in 60 days. That's the JCS card. And you also have 24 hours of community service, $270 in court costs, $150 public defender fee. Okay, any questions, sir?
Yes, sir.
Thank you very much. Let's just do out of custody at this point. We need to take a break here in a little bit too. Is that all you're out of custody, Ms. Farkas?
Yes, Your Honor, that's everyone I've got at this time.
Yes, Your Honor. I've got one out of custody. I'm ready to call, Your Honor. It's Mona Gray.
Ms. Gray making her way to the podium. We have a plea agreement to file in the case. So I may approach her?
You may.
You have no objection to this court sheet on this, I can make out the margin.
Thank you. Would you please announce the terms of the agreement?
Yes, Your Honor. Ms. Gray will be entering a plea of no contest as charged. The withhold of adjudication should be placed on 36 months of probation. We'll ask the court to waive the cost of supervision. Standard court costs, public defender fee, $490, crime against minors. Should require the mental health evaluation, appointment to be made within 60 days. Any recommended treatment to be begin within 60 days of the appointment. Take meds as prescribed. No unsupervised contact, or no contact with ERN, date of birth, May 11, 2018, and no unsupervised contact with minors.
That is the state's agreement, Your Honor.
So ERN? Who is that?
That's-
I know it's a child, but is
Yes.
it her child?
Yes, it is, Your Honor.
Is there a dependency case?
I believe they're working on TPR.
Okay.
We have spoken with DCF and no contact is what they're asking for at this time.
This is not the way this should happen. You're essentially having no contact in a criminal matter that, when the whole structure of our dependency system is designed to do it, they have a no contact. Our whole system is built on the issue of rehabilitation.
Yes, Your Honor.
And there's no rehabilitation here. As a matter of fact, by entering this no contact order, they're gonna be arguing that in the TPR case, that she's got a criminal case, that she's got no contact.
Yes, Your Honor. And I'm aware of that, and based upon my conversation with Ms. Gray, she's actually agreed to that provision in this case.
Okay, very good.
And just in all honesty with the court, Ms. Gray is choosing this path because I think she sees it as the best option for a child to be able to move on with her life.
I understand that often is the case, and I appreciate her taking that stance and actually thinking about somebody other than herself. So that's not always an easy thing to do, but okay. Very good. So I'm gonna ask you some questions, Ms. Gray. I need to swear you in. Do you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of the plea agreement, and I see you've signed the written plea agreement. Have you read this closely and gone over with your attorney in detail? I see he's marked it up, so that usually indicates he's been going over it in detail with you. And you understand that by entering into this plea agreement here today, that you're waiving the right to go to a trial to contest all this and waiving some other constitutional rights. Do you understand that?
Yes, Your Honor.
You believe that's in your best interest to do that?
Yes, Your Honor.
And you're doing so freely and voluntarily?
Yes, Your Honor.
Okay. Very good. And did I ask if this is the state's agreement?
It is the state's agreement, Your Honor.
Therefore, Ms. Gray, as I said, I will accept your plea agreement. There'll be a withhold of adjudication on the single count, and the court will sentence the defendant to 36 months probation, waive the cost of supervision, $515 in court costs, $150 public defender fee, and then $491 crimes against minors fee. As a condition of the probation, you must seek a mental health evaluation, appointment within 60 days, and then any recommended treatment within 60 days after the appointment, and take any medication as prescribed. As a condition of this, importantly, there is no contact with the minor ERM. The date of birth is contained in here, and no unsupervised contact with any minors. Okay? And that will be during the entire term of the probation. Okay, any questions?
No, Your Honor.
Okay. Good luck, ma'am.
Thank you.
Your Honor, I have several out of custody in the bank.
Okay, I was wondering whether if we could take a short break.
I'm assuming, Your Honor, just for the court's consideration, there are no male inmates for the public offenders, so we're gonna need to talk to quite a few of them with agreements and so forth. So we may wanna take the break, but maybe do it after these out of custody, but whatever Your Honor directs.
Okay, well, we can do a few more, and then we'll take a break.
Thank you, Your Honor. Mine won't take very long.
No,
but
that's
there are
all right.
2 or 3, please. First up is Tommy Allen Jr. Mr. Tommy Ray Allen Jr. is docket number 77, court case 23 CF 343. I believe the state has an announcement.
Yes, Your Honor. At this time, the state will announce a null pros of this. This is a failed PTI hearing.
Very good.
Free to go.
Thank you. Good. Thank you.
Your Honor, next is Shannon Allman with a plea agreement, Your Honor. And Your Honor, there is also one of those DMV orders, and there's also a score sheet. We don't question the score sheet. May I approach, Judge? And I'm going to give probation a copy.
Thank you.
She's already met with probation, or that's what she represents to be. Your Honor, under the terms of the agreement in 23 CF 2805, Ms. Shannon Lore, L-O-R-E, Allman, A-L-L-M-O-N, her case is being resolved as follows. Adjudication of guilt as charged on counts 1 and 3. 1 is a felony, 3 is a paraphernalia misdemeanor, and also adjudicate guilty to a lesser included offense misdemeanor paraphernalia on count 2 instead of another possession of controlled substance. So she'll have 2 paraphernalias and 1 possession of controlled substance felony. There will be 24 months standard probation on count 1, time served on misdemeanor, substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days, And there's an asterisk there that she may show proof of completion of inpatient drug treatment for consideration by state probation. She is undergoing treatment, so she's going to be going through that with probation today to see what the backstop will be on the baseline on her treatment. Random urinalysis, 48 hours community service, maintain gainful employment or complete 3 applications per week, $6.15 court costs, $150 PD fees. She does live in Florala, Alabama, and she's asking for the court's permission to seek transfer pursuant to the interstate compact, Your Honor.
Okay. Just one point of clarification. The requirement to maintain gainful employment or complete 3 applications a week, that would be, I'm going to say suspended, I don't know if that's the right term, if she enters into an inpatient treatment program, wouldn't she? I just want to make sure we clarify it here so it isn't something that
Yes, but
crosses her up.
that is not going to be applicable in her case. She's already done treatment
Okay.
and is doing.
You're just seeing whether it applies.
Yes, Your Honor. She's under an ongoing outpatient treatment
Okay.
regime at this time.
Very good.
So
Very-
it is a good point to be mindful of. For some clients, it could be an issue.
Okay, very good. Stayed in agreement with
That
this.
is the state's
Clinton?
agreement, Your Honor.
Okay.
Your Honor, she's asking for permission to pay off community service if she can. Does the state have an objection?
No,
to
Your
that?
Honor, the state doesn't object.
The court will be fine with
So I'll
that.
add a second asterisk, may pay off community service.
Very good. You're also asking the court to sign the order regarding
The business
the
purposes
driver.
only?
Yeah, business purposes.
And there is a complexity is that she does live in Florala, so she may be seeking an Alabama license, so that order may have very limited effect, if any.
As in, they don't care what we do down here in Florida, up in Alabama, and
But-
quite frankly, vice versa.
But it won't hurt, Your Honor, and at least show that the court,
Sure.
if she's accepted under Alabama or Florida DMV requirements.
We'll do what we can do. Sometimes that's all you can do.
Thank you, Your Honor.
Okay. Ma'am, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. So, you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement. So I just want to make sure, have you read this closely and gone over it in detail with your attorney?
Yes, Your Honor.
And you understand that by entering into this, you're waiving the right to contest this and go to a trial and all that, all your constitutional rights. And you believe that's in your best interest?
Yes, Your
You're entering this freely and voluntarily?
Yes.
Nobody threatened or coerced you to get you to enter into this, did they?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on counts 1 and 3 as charged, and to the lesser included misdemeanor of possession of paraphernalia on count 2. Statutory cites included in here. So basically you have 2 misdemeanors, 1 felony that you're pleading to. The sentence on the 2 misdemeanors is technically credit for time served. So you basically have completed the sentence on that, on the 2 misdemeanors. There will be an adjudication of guilt, however. As it relates to the single felony charge of possession of controlled substance, you're sentenced, the main sentence on the is 24 months of probation as to that count. And you are required to do a substance abuse evaluation within 30 days with any recommended treatment in 60. And there's a caveat that you can show proof of inpatient that may meet the requirement. In addition, you've got to maintain gainful employment or 3 applications a week, standard court costs, and it says the defendant may seek transfer. We just understand that we don't have anything to do with that. Even our probation doesn't. It's an interstate thing between probation and probation, but certainly there's a standard way. They generally don't mind it, but we can't promise it. Okay. Any questions? Okay. Good luck. Now I'm signing the order as it relates to the Florida Department of Transportation.
Thank you. I think it's DMV, Your Honor. I'm sorry. It may be Department of Highway Safety and Motor Vehicles.
Okay.
Thank you.
Put it.
Your Honor, next is Jack Philip Boardman. Mr. Boardman is number 83 on the docket. Your Honor, I am in discussion with Ms. Sharpless to work out an agreement. We're not seeking a full cycle, but the state needs to confer with the victim a bit more. If we could continue him, is there a way to do a miscellaneous in this September?
Sure. We can do September 17th,
Okay, thank you, Your Honor.
9 a.m.
Got it? Awesome. Yes, thank you, Your Honor. Next, Your Honor, is Hamilton Boykin. Mr. Boykin is 85 on the docket. Your Honor, this is one also where he's speaking to his family about what he wants to do. We have an agreement that is probably worked out, but he needs to have a brief continuance. Can we do something like September 17 on him too, Your Honor?
We can do that. We'll continue this September 17th for a plea.
Okay, thank you. Your Honor, next is Miss Sherry Brooks with an agreement for it's a misdemeanor agreement, Your Honor, and it will be a JCS supervision. She had already signed it, but the state signed it on a different copy, so I'm going to have her sign it again. Thank you. Yeah, that's for you. And this is for you too. You can hold it after. I think this will be the last one before the break, Your Honor. May I approach?
You may. Thank you.
Thank you, Your Honor. Under the terms of the agreement, Ms. Brooks in 23 CF 1522 will be changing her plea to no contest on a withhold adjudication to a lesser included offense, second degree misdemeanor petty theft. The statutory reference is given. 6 months probation with JCS supervision, no trespass at Walmart on Beale Parkway in Fort Walton Beach. And a theft class, eligible for online reporting because she has transportation problems, lives in the north part of the county, Your Honor. No drugs not prescribed, no firearms during supervision, $270 court costs, $150 public defender fees.
Your Honor,
State. Ms. Brooks, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God. So, you heard your attorney state the terms of the plea agreement,
Yes, sir.
and I see you've signed those same terms in your written plea agreement. Have you gone over read it closely?
Yes,
And
sir.
gone over it in detail with your attorney?
Yes, sir.
You understand that by entering this, you're waiving the right to go to a trial,
Yes,
waiving
sir.
some other constitutional rights. You believe this is in your best interest?
Yes,
You're
sir.
entering this freely and voluntarily.
Yes.
Based upon that, the court will accept your plea. There'll be a withhold of adjudication as to a lesser included offense of second degree misdemeanor petty theft. Statutory cite is contained in the agreement. Court's sentencing you to 6 months probation, JCS probation, with the condition specifically of no trespass at Walmart on Beale Parkway in Fort Walton Beach. You must complete an anti-theft class. You're eligible for online reporting. No drugs not prescribed, no firearms during supervision, standard fees and costs.
Yes, sir.
Any questions?
No, sir.
Thank you very much.
Thank you, Your Honor.
Okay, so let's take a mid-morning break. We got 10 or 15 minutes.